Ladies and gentlemen, thank you for joining us today and welcome to our firm's Investing in India program. This is the 11th webinar in the series. My name is Tanu Banerjee and I'm a partner in Khaitan's Corporate and Commercial Practice Group. I would like to extend a very warm welcome to every one of you, wherever you are around the world. Investing in India is a webinar program curated especially for existing and prospective foreign investors in India and their advisors to enhance understanding of key issues in doing business in India. Over time, the program seeks to cover all issues and areas of interest to our audience. Intellectual property plays a vital role in today's innovation-driven economy and, of course, is a key factor influencing investment decisions. For foreign businesses entering India, understanding the IP framework is crucial, not just to protect their brands, but also their technology and creative assets. India's IP regime has evolved significantly over the years, aligning with global standards while also addressing local business realities. Awareness of registration, enforcement, and commercialization mechanisms can help investors mitigate risks, safeguard competitive advantage, and unlock the value in innovation. Our session today will provide an overview of India's IP landscape, key legal protections, recent developments, and strategic considerations for foreign businesses operating or wanting to operate in India. On the next slide is the agenda for today's program. If you have any questions, please submit them using the facility provided in the webinar portal during the webinar. If we will try to cover all questions during the webinar itself, but if we do not cover questions, we will respond offline by email after the webinar. Also, as a matter of course, a copy of the presentation, summary notes, and a recording of this webinar will be sent to you after the webinar. Let me now introduce our speaker for today. All registered participants should have already received an email with the resume of the speaker and myself. So I will keep the introductions brief for now. Our presenter today is Shailendra Bhandare. He's a partner in our intellectual property practice group. I'd like to invite Shailendra now to take over and kickstart the session for today. Over to you, Shailendra.
Thank you, Tanu, and thanks for making my life easier by setting the context. So I think, as Tanu mentioned, I think intellectual property is one of the key aspects which any investor looks at before investing in India. And the kind of regime that we have in India, it's 150 years old, but it has gone through phases. And the phases such as you had the earlier pre-British era and the post-independence regime and the opening of the regime in 1991. So it's important to look into what is the framework in India in terms of the IP regime. What are the IP disputes regimes in India? What are the differences between the Indian and global IP frameworks? Certain practical consideration and differences which you would see, and the nuances which are relevant for any foreign investor. The recent trends and the case studies which probably will set the tone for the future, and maybe foreign investors should be ready with those as well, because it's not just about what you see presently, you also need to gear up for the future. And that's basically the agenda which we have for today's presentation. And let's kickstart this with the first one, with on the introduction front, which is related to why India and why investment in India and why IP in India becomes relevant. Highest population, so largest market. So obviously any investor is certainly going to consider India from a market perspective. Labor-rich country and outsourcing are the two strong pointers which drive foreign investors to India from an R&D and software development perspective, which are the topmost amongst the lot as such. Also, India is an innovation hub and a digital penetration in India due to the internet penetration in rural areas makes it more easier for any investor to tap the Indian market. And with this, you also see the government improving on the ease of doing business in India regime. And you've seen a lot of digitization which has occurred on the filings, be it for IP filings or for that matter, company filings. And there is digitization, QR codes, you name it and you'll see digitization everywhere, which has eased several aspects in terms of the earlier license Raj, as we used to call it, making things more simpler. And with that, you see a 44% rise in IP filings in the last 5 years. And if one had to just take a statistic, in 24-25, you saw 68,000 patent applications being filed in India and over 538,000 trademark applications being filed in India. And now that just goes to show as to why India has has taken the center stage. And I would also say there are geopolitical reasons also for that, not just because it's the largest population, but I think India has taken the center stage, and protecting IP has become that much more important. Now, before we move to the next slide, I think it is important that we look into the entire phases as we spoke about earlier. That before independence, you had the British system, which basically controlled the entire the IP regime as such, and it was more open and it was more related to how the East India Company would function in India. And post independence, there was a lot of thrust on self creation and giving more priority to Indian companies, which is why the regime was more closed and was not open for foreign investors. But come 1991, India realized that it can't just work in a silo, and the regime was opened on the regulatory front. IP laws were changed and amended to a larger extent, and now you see that India is TRIPS compliant. And for records, it's 150-year-old IP regime, taking it back to the British system. And in terms of the statutes which we have, most of the IP statutes are central statutes. There are some which are state statutes, like the Bootleggers Act, which is more from the media and entertainment side, but of course copyright aspects are also related to it. But all in all, now you don't see any bias against foreign companies as it used to be pre 1991. Can we move to the next slide, please? So I think from that perspective, let's just understand what all statutes we have in India. You have the Patents Act, so all acts are protected, and they are statutorily protected as such. But the only thing which is left out and which is wanting right now, it's the trade secret statute. We don't have a trade secret statute as of now. There is already a chatter, a lot of lobbying and a lot of push towards having the trade secrets bill being put up before the parliament and being finalized, and shortly we should have the trade secrets statute in place. But otherwise, you see the Patents Act, the Designs Act, the Semiconductor and Integrated Circuits Act, Plant Variety Act, trademarks and copyright, so on and so forth, and of course geographical indications. So as we move further to the next slide, it's also important to understand that there are certain connections between these acts, like geographical indications and collective marks may have a certain synergy. We won't dwell too much into it, but those nuances also need to be considered. Now, just as a quick snapshot of what do the usual suspects like trademark, copyrights, patents, and designs project from an Indian standpoint, and what are the nuances? Trademark registration is optional, but if you have a statutory protection, you get certain higher rights. Like the R symbol, you cannot put in if the mark is not registered in India, particularly for foreign investors who are importing goods into India from other territories. And if there is an R symbol mentioned on that product packaging, it is important to note that under the Indian regime, if the R symbol is used without the mark being registered in India, it's a penal offense. And one needs to be very careful before putting the R symbol. It has to project that it is registered in a particular country, and it's best to mention that it is registered in a particular country if it is not registered in India. For copyright, registration is optional. Patents and designs, the registration is mandatory because it is a creation of statute. So there is no common law patent or there is no common law design. Of course, in the recent past, we have seen courts given credence to passing of actions in a design related issue. In terms of tenure, pretty much on the lines of international standards, the tenure for the trademark renewal term is 10 years, and you can renew it in perpetuity. For copyright, it is usually life of the author plus 60 years. For patents, it is 20 years. And for designs, it is 10 years for the first term and 5 years, which is the last renewal term as such. Territorial scope for registration for trademark is India. And for copyright, it is again India on paper. But if you see the next row, you would observe that there is extraterritorial protection when it comes to trademarks in case of transborder reputation or Madrid Protocol or Paris Convention, if that be the case. In terms of copyright, because of the Berne Convention and the UCC, which is a Universal Copyright Convention, your protection for copyright, if you register it in India or if you create a copyright in India, the protection is extraterritorial. But that's not the case with patents and designs. These are strictly territorial, and there is no question of transborder reputation or a foreign patent being made applicable in India without registration in India. In terms of timelines for registration, trademark registration, which used to take, say, probably more than 10 years earlier, during my formative years, we used to receive registrations after the date of first renewal. But now, fortunately, things have improved. And you see registrations are obtained within 1 or 2 years. For copyright, it is 1 year. For patents, it could stretch to 2 years. And for designs, it could be 1 year or probably a year and a half. Now, as we move to the next slide, it is also necessary to consider certain overlapping aspects which are there. So although you have these separate IPs, which I just discussed, there are certain overlapping protections which are also important, and that we will discuss it in the future slides. Moving on to the IP disputes regime in India. Now, what are the IP disputes which you see in India typically, and where do they originate from? The first one is appeals to courts from IP offices. So all the decisions of the IP offices, which the applicants are not happy, or probably opponents or the counterparties are not happy in an opposition proceedings, all the appeals go to courts from the IP offices. And not long ago, we used to have an intellectual property appellate board, which is unfortunately now being abolished. There was a huge furor about this decision because that has led to a chaotic situation with the Indian courts, which are already grappling with a lot of backlog. But I think we will see certain changes happening shortly, with IP benches being set up in the Indian courts, and that should probably ease things on the backlog front. We spoke about oppositions, cancellations, and revocations at IP offices. That's the tribunal-related litigation which one would come up with in IP offices. Civil suit for IP violations, which is what traditionally most IP owners would utilize. You also have arbitrations in contractual disputes. IP disputes are arbitrable in India now. A few years back, the thought process was that infringement action cannot be taken up under arbitration because it's a right in rem. But now Indian courts have held that even infringement actions between the two contracting parties can also be decided by way of arbitration. The next one is actions against disparaging and misleading advertisements. Now, disparaging and misleading advertisements in a competitive environment has picked up in a big way. And these are ancillary matters to intellectual property matters. And we see a lot of combined actions for advertisements and IP disputes being taken up. Domain name disputes, UDRP and INDRP actions. So India has its own dot-in dispute resolution policy, which is akin to the UDRP, which is a Uniform Dispute Resolution Policy. But there are certain differences which exist between UDRP and INDRP. We'll look at that in the next slides. In terms of enforcement proceedings, Customs Office is also utilized to record and to suspend imports which are counterfeit or which are pirated or which are infringing. And of course, criminal proceedings with police authorities and magistrates. Can we move to the next slide, please? Now, in terms of the criminal proceedings and the civil proceedings, it's important to understand the differences if you're a foreign investor. And usually we see that foreign investors end up using the civil matters instead of the criminal matters, because there are a lot of other complications related to criminal matters. So in terms of admissibility, all IP matters are admissible for civil remedies. In terms of criminal matters, design and patent infringements do not enjoy criminal reliefs. So that needs to be borne in mind. Of course, if you're looking at a data theft or a technology theft, probably that's something which would be under the criminal proceedings, but that's not typically under the patent regime. That's pure play offenses or a criminal offense which would be included from a theft perspective. IP disputes fall under the Commercial Courts Act, which was enacted a few years back, and that has helped in faster redressals. There are specialized IP benches being set up in several courts, but not in all courts. So we will discuss about it in the next slides. So in terms of specialized IP benches, I think one needs to bear in mind that not all courts have IP benches, and choosing the forum becomes that much more important. There is special jurisdictions for registered marks and copyright holders. So if a plaintiff holds a registered trademark or is the owner of a copyright, the plaintiff is in a position to file the infringement action where the plaintiff carries on business. So that's an important plus and a benefit which any IP owner would have should he or she own the registered mark or a copyright. So they can file the action where they are carrying on business in India. So of course, it's not forum shopping, it's a special jurisdiction which has been granted under the Trademarks Act and the Copyright Act. In terms of criminal actions, there are certain problems which you see on the trademark front, and that's something which we have been trying to push through our advocacy initiatives. And one of the top points is that you need an opinion of the trademark office before initiating any trademark infringement action under the criminal regime. But the good part is that trademark and copyright violation under the criminal reliefs is a cognizable offense. And what I mean by cognizable is that without a warrant, an action can be taken. So that's a big plus again, although you have a problem with seeking opinion, but because it's a cognizable offense, things become much easier. Now, for the initiation bit, you can have an authorized signatory for civil proceedings, but for criminal proceedings, you need the complainant or the employee of the complainant to be the person who lodges the complaint. And that's a big dampener for foreign investors, because many of the employees do not want to get embroiled in the criminal proceedings and to deal with police authorities, which are at times difficult in certain places where IP regime is not that aware in terms of the rural areas. Search and seizure under civil proceedings, it is possible. Ante-pillar orders, as they are commonly referred as, can be initiated by seeking specific search and seizure prayers within the civil proceedings. And for that, you need the court commissioner, which the civil courts would appoint. In terms of criminal remedies, search and seizure is only possible through police officials. And that's a normal thing. In terms of reliefs, injunction is the topmost one. And we'll discuss why injunction is the topmost relief, which is preferred in India. And people don't tend to wait for costs and damages until the trial finishes. John Doe orders and dynamic injunctions are now widely used. So you don't need to file multiple action. It's sort of a class action, sort of an action which you can file against multiple defendants and unknown defendants, and you don't need to file a fresh action if it's a dynamic injunction. Now that's a big plus when it comes to enforcement strategies in India. For criminal actions, obviously you don't have injunction and cost and damages, but you have fine and imprisonment as the relief. In terms of imprisonment under the civil remedies, it's only possible under the contempt action. So contempt actions are possible and disobedience actions are possible in civil proceedings. And imprisonment, as I said, is possible under the criminal remedies. Can we move to the next slide, please? Now, moving on, in terms of the civil proceedings, now what are the stages and what is the life cycle which one needs to go through under the Indian regime? Filing the suit, you could probably prepare the suit if all the documents are present within a week or so, and you could have the matter listed for the ad interim or the pre-interlocutory stage within a week from filing the suit. And probably you could also have an ex parte decision being passed if it's a clear-cut case within first week itself. And to that extent, the interim stage or the ad interim or the interlocutory stage is the key stage under Indian circumstances. No one really waits for the trial because the trial is likely to take 3 to 5 years. And the amount of money which you're likely to get in terms of damages probably may commensurate with the kind of legal fees which you incur on lawyers. Of course, it's a problem for us as we lawyers, but just mentioning from a practical standpoint. So if the matter is somewhere over, you think that the counterparty is willing to undertake that he or she will not infringe, it's best to settle the matter at the interlocutory stage rather than waiting for the trial. Of course, there are appeals before the division benches, Supreme Courts. In a highly contested matter, it could stretch into multiple appeals and going right to the Supreme Court. Can we move to the next slide, please? Now, in terms of the next topic, I think this is one of the most important one for foreign investors, because this would discuss about the differences which we have between the global IP frameworks and Indian IP framework. And to begin with, patents is obviously the technology from an India standpoint becomes that much more important. And patent licenses are some things which are heavily looked at from a technology transfer point of view from any foreign investment perspective, particularly for joint ventures. So under the Patents Act, we have this peculiar section 140, which talks about certain restrictive licensing covenants being prohibited under the Indian regime. And the reason for it is also related to the competition regime, because certain things which are listed in this section are also to avoid anti-competitive practices. But the topmost one, which I would like to discuss, is that exclusive grantbacks in a technology license agreement which has patents as the core of the technology license. Exclusive grantbacks are prohibited for a patent license. So if you're looking at an improvement which needs to be granted back exclusively to the patent owner, that is prohibited. And that could actually create a lot of problems where IP owners would want to own the improvements and the derivative technology. So that needs to be borne in mind, and structuring is important in that regard. Foreign filing license or first filing in India for Indian resident inventors is very important. And this is borrowed from the US regime. Also, and under UK regime, we have seen a similar provision, where if there is an invention which involves Indian resident inventors, the Indian law says that you need to either seek a license from the Indian Patent Office if you intend to file the patent outside India first and not in India first. Or if you want to first file it outside India, then license, or you first file it in India itself. And the requirement is of Indian resident inventors. So the word resident is very important. It is not citizen, it is not national, it is resident. So there is a high likelihood that there could be a foreigner who's staying in India who basically is considered as an Indian resident under the Indian tax regime, and who invents certain things being an Indian resident in India, who would be required to seek this license if he or she is an inventor. So this is quite important, because this is one of the rare penal sections under the Patents Act. Exclusions from patentability has been a pain point for many foreign investors, particularly in case of software, business methods, and in the pharma world related to evergreening of patents. So software per se is not patentable, business methods are not patentable. And in terms of pharma evergreening, I think the efficacy becomes that much more important if you need to actually register a patent in relation to a drug which may relate to certain things which was already patented earlier. Compulsory licenses are possible but rare. Some have been granted and many have been rejected. And India looks into the public health sensitivity when it looks at compulsory licenses. And related to that is a filing under the Patents Act called the working of patents filing, which basically each patentee has to file before a certain time frame mentioned under the Patents Act. And that could be looked at from a compulsory licensing perspective. If the patent does not work, and if there is a monopoly which is being hoarded in India, and if there is public health sensitivity, there is a likelihood of the government looking into compulsory licensing. Rare, as I said, but something to be looked at. Under the copyright regime, registration is not mandatory, as we discussed, but may be useful for criminal actions. In the rural areas, probably police authorities may not be aware of copyright regime, that registration is not mandatory. They will always demand, show me a document which is authenticated by the government, which allows you to take this action. So maybe in practical situation, you may register copyrights. Work for hire concept is not completely recognized in India. In case of producers, it is, but not for all copyright works. So therefore, assignment clause becomes necessary, and that too in writing. There is no implied assignment clause. It has to be in writing, and the term and territory of assignment needs to be specifically set out. If you don't set out the term and territory of assignment, it is deemed to be restricted to a term of 5 years and to the territory of India. Also, we have a concept of reversionary right, which probably has trickled down from the old British system. But under the reversionary right, if the assignee does not utilize the assigned works, assigned copyright works, within a period of 1 year from the date of assignment, there is a deeming provision which states that those works would automatically go back to the assignor. So typically, we also include a clause for waiver of reversionary rights. The last one is the copyright societies or the IP holders, which have created a kind of nuisance when it comes to certain musical aspects and musical rights which these copyright societies control. And there are multiple copyright societies or rights holders. So there is no one-stop shop in India where you could just get a license which covers all copyright societies. So all the reunion parties or the alumni parties which you see for your Indian subsidiaries, one needs to be very careful that that does not go in the public domain. Because if there are songs being played as part of the private event, which the copyright societies may still consider as a public performance, they may send you notices and notices to directors as well, where they would try to demand damages for using songs without their permissions. So copyright society aspects needs to find a place in your IP handbooks which go out to your Indian subsidiaries. And that's the localization which we will discuss about in the next slides. So moving on, in terms of trademarks, there's a long laundry list, and I'm sorry for that, but trademarks have certain nuances in India. India is a first to use system, so affidavit of use is required for claiming use. And we've seen many foreign applicants being a bit cagey about things such as, okay, we don't want to claim use because that requires a lot of administrative cost. Do not do that, because it could be fatal for your future enforcement strategy, because your rights would be calculated from the date of first use in India and not from the date of the application. So if there is use, wait for that filing, get those documents and instruct your attorney to include that claim before you file the trademark application. India follows the international exhaustion system. So parallel imports is a big problem under Indian conditions. If there are original goods coming into India from other sources and not being sold by the Indian authorized dealer, the case is sub judice, and there's a lot of push to make this into a domestic exhaustion system. But as the law stands as on date, we follow the international exhaustion system. Well-known mark status is possible through the trademark office. So you need not wait for the courts to adjudicate whether the marks are well known. You could actually make a trademark, rather an application with the trademark office to adjudicate that your mark is well known, if at all it is well known, of course. UDRP is not binding on courts. The Uniform Dispute Resolution Policy for domain name disputes is not binding on courts, but the dot-in dispute resolution policy, or the INDRP, is binding on Indian courts because INDRP follows the Indian Arbitration Act. And that's why Indian courts look into INDRP as a binding decision. Trademark office permission is required for criminal proceedings, we discussed. Transformation and divisional applications are not possible under the Madrid system in India. A big problem for foreign investors. If you are thinking that, okay, Madrid system is the best system, you have a registration on board, or you have a new launch, you try to register it, you get a registration, but within 5 years, if the base registration abroad is cancelled, you do not have a provision in India to transform it into a domestic application. You necessarily have to file a fresh application, and that's a big problem. Again, divisional applications are not possible under Madrid Protocol system in India, but those are possible under national system. So if you are looking at an objection in one class, you may have to delete that class rather than dividing that application. Again, multiple priority claims are not permitted. You may have to delete multiple priority claims. If there are multi-class applications also, priority claims for each class, which are separate, would be considered as multiple priorities, and those may have to be deleted. Subsequent designations under Madrid are not possible for applications which have filing dates before 8th of July 2013. 8th of July 2013 is the date when India acceded to the Madrid Protocol. Quality of examination in India is likely to leave a lot of things as a problem situation, because the kind of examination which we see in India could actually affect your brand launch strategies, because one objection and one hearing being set up under the Indian examination system could just delay things in terms of the registration process. Suspension of registration process is not possible. So if you're looking at a prior citation during the examination process, you cannot request for a suspension of registration process as you have in US, but you don't have it in India. So you may have to go through the hearings, probably there may be a refusal, and you may have to file an appeal to that extent. Assignment of goodwill does not take effect if it is without, rather assignment without goodwill does not take effect if the agreement does not have a clear language on goodwill. So you need to have the language that the assignment is with goodwill. If it is without goodwill, or it is indeed without goodwill, you need to seek directions from the trademark office, publish the assignment in the local newspapers, and it is only then that it would take effect. So an assignment with goodwill will take immediate effect. An assignment without goodwill will not take immediate effect. There are no forms under the trademark regime to record encumbrances. So you merely need to file intimation letters to the trademark office and report that there are encumbrances recorded. Registration of licenses, trademark licenses, in case of registered trademarks is not mandatory. In fact, it could be complicated and one should avoid doing so. Of course, there are mixed opinions on this, but there are several problems associated with the procedures which foreign investors at times don't prefer to go through. Can we move to the next slide, please? So in terms of the other aspects which we need to look at under the patent regime and the design regime from a differences point of view, can we move to the next slide just in case so the viewers can have a perspective? Thanks. So in terms of designs, I think definition of design excludes trademarks and artistic works, which is a major difference from the EU regime and the UK regime, where probably they could coexist. And you could have problems where you have overlap in the international regime, but under the Indian regime, these are mutually exclusive. Again, there is no recognition of Locarno classification for all the classes of the Locarno classification. So graphical user interface, logos, etc., or the miscellaneous category which you see in the Locarno classification is not something which is completely recognized in India. And that has led to a lot of problems when it comes to gaming technologies or gaming companies who are wanting to register their graphical user interface under the designs regime. But yes, you can register that under the copyright regime, and you anyway have an inherent copyright protection for graphical user interface. one needs to also look into the exhaustion of rights. Like under the Copyright Act, we have this peculiar provision, Section 15, which states that if any copyright work is capable of being registered as a design, and if that particular copyright work is manufactured through industrial process 50 times, you may probably lose the copyright as well as the designs. Now it's debatable, what do you mean by capable of being registered as design? So if it is not capable of being registered as a design, obviously then you're looking at a copyright work itself. But that's something which one needs to be careful about when it comes to exhaustion of rights. The Hague system for international registration is not acceded to. So like the Madrid protocol for trademarks, you cannot utilize an international registration system for designs. And that's partly got to do with India not being harmonized in terms of the classification as yet. And India has not amended the Designs Act. Trade secrets, as we discussed, are not something which are enjoying statutory protection, and it's only through contractual protection then you can protect trade secrets. Now that's a big problem for foreign investors, because you're only relying on contracts, and then you're at the mercy of the right court, and whether that court is capable to understand the trade secret contractual arrangements and provisions in India is something which bothers most foreigners. In terms of IP disputes, judges for arbitrations and infringement actions could be different. So if you're going to utilize your arbitration clauses for IP infringement with your Indian partner or an Indian subsidiary, one needs to be careful that that particular matter may be heard by an arbitration judge and not by a judge who is actually handling the infringement action and who's more specialized to handle IP infringement actions. Most battles are fought at the interlocutory stage. We discussed about it. No need to wait for the trial if you achieve your goal at the interlocutory stage itself. Not all courts have IP benches. So when you decide on the jurisdiction in India, in your contracts, one needs to be careful and choose the right forum in the agreement so that you have the IP benches which hear you for those matters. Discovery process is narrower in India. We have a part of it, but it's not as detailed as what you see in US. Grant of damages and the trend for punitive damages is going up, but it's restricted to certain courts, and we don't have a jury system. Although we may have a larger bench which may be set up for a point which is contrary to certain prior decisions, but it is necessary that you decide on the litigation strategy looking at all these three things. Can we move to the next slide, please? So looking at the other aspects which are also important from the differences perspective, the practical consideration, just to continue, I think they would differ for the various types of transactions that you're looking at. I think one is the India entry aspect, which is formation of Indian subsidiary. Now, in terms of formation of Indian subsidiary, of course, name approvals, company name approvals, LLP name approvals, merely looking at the trademark office search is not good enough. You need to look at the company name approvals and the problems which may arise there. Investments, private equity investments and family office investments may have a different treatment under IP. Share purchase agreements probably may not require a detailed sort of a diligence. Mergers and acquisitions would obviously require a larger diligence. Joint ventures we discussed. Joint ventures would have more thrust on the technology front and the joint development front and the improvements which come out of it. Restructuring. Now, restructuring is again a tax related aspect as well. So those acts would also be necessary when you're looking at IP restructuring. Securitizations and encumbrances would have a different way of handling things. Slum sale, more than IP, in case of slum sale transaction, tax would take the center stage. Formation of global capacity centers. Now, who owns the IPs? How would IP creation be dealt with? Now, those aspects would become different, and one needs to be careful while deciding on their India entry or investment or in mergers and acquisition. Before we move to the next slide, I think it is also important to look into the outsourcing side of things, because under the outsourcing regime, the employee aspect and how does the employee IP creation and the ownership from an Indian employee, how is it structured, becomes that much more important. Can we move to the next slide, please? And as I was saying, outsourcing, if you have an employee directly assigning the IP to a foreign company, it could lead to problems under the tax system, because it could lead to a permanent establishment sort of a situation which needs to be checked under the tax regime. So when you're structuring the employee IP ownership aspects, it is important that you also look into the tax aspects. And we discussed about it. Due diligence is all the more important. Name approvals for Indian companies. So merely monitoring trademark office records or websites is not good enough. You also need to monitor registrar of companies. Differences under the IP framework, which we discuss, need to be discussed with your counsel, and one needs to find a way out for localization. Structuring of Indian investment and entry is important not only from an IP structure perspective, but also from a tax perspective. You'll have service agreements between global parent and the Indian subsidiary, and the IP treatment which is dealt with under these agreements. But tax would take center stage here. Choosing the correct state for setting up shop. For instance, if you're looking at a software-based company and the patentability which may come up through software, probably the Chennai Patent Office is more important, because that's very close to Bangalore, which is the Indian Silicon Valley, as they call it. Chennai Patent Office is more equipped to handle computer-related inventions. So choosing the jurisdiction to set up shop from an IP perspective may also become important. Dispute resolution clauses. Not all countries are reciprocating countries under the Indian Civil Procedure Code. So if, say, you're looking at a US company which is more familiar with US courts and tries to include US courts as a jurisdiction within the agreement, it could lead to a problem if one needs to enforce that foreign decree into India, because Indian courts will not recognize the US decree, and you may have to file a fresh action under Indian courts. So jurisdiction becomes that much more important. Stamp duty consideration. Stamp duty is a state subject, and it has implications for IP licenses and IP assignments. For instance, Chennai or state of Tamil Nadu and state of West Bengal have the highest amount of stamp duty when it comes to IP assignments. It's at a whooping 7% of the consideration value which is mentioned. So from a stamp duty perspective as well, one needs to structure the IP commercialization contracts. Exchange control consideration, well, not typically within the IP realm, but you need to seek counsel on exchange control considerations, because certain authorized dealer banks may raise objections if there is IP being transferred from a non-resident, from a resident Indian to a non-resident company outside India. And the authorized dealer banks, or the AD banks as we call them colloquially, they may insist that an approval is required from the Reserve Bank of India for making such transfers. So seek counsel on that. Avoid filings in the names of local partners. We have seen many foreign investors trying to do that for ease, for a short-term benefit, but it could lead to issues in futures. Localization of IP clauses in agreements is important. We saw the term and territory aspect under the copyright law, quite different as compared to foreign laws. And localization of IP contracts through your counsel is very much important. Litigation budgeting is important. Don't look at the chances of success or the trial, how long will it take. It's important to enforce rights as quickly as possible. If you don't enforce, your interlocutory reliefs would be affected. Because for interlocutory reliefs, it is important that you show the urgency. And if you take time, it is likely to create problems in getting those reliefs. Can we move to the next slide, please? And I think from an interlocutory relief perspective, it is also important that, like we discussed, that if it can be closed at that stage itself, you can seek an undertaking from the other side and close it at that time itself. Handling trade secrets with restricted disclosures is important. Because we don't have a statute, it's important that we restrict the disclosures. Find a close-knit group which handles trade secrets, and then probably certain things could be disclosed in a piecemeal manner rather than disclosing it to the entire employee within a company. Managing ownership of joint developments and improvements in joint ventures becomes important, especially in a patent license perspective. And trademark issues from a Madrid Protocol perspective, is we mentioned about it, may not be the best aspect. Claiming use is important. Separate class filings are preferred because multi-class applications may pose problem. You need to leverage overlapping IP protections like copyright plus trademarks. If there are dual protections, make use of that. Backlogs at the Indian offices could affect the India entry of for IP launch strategies. We can move to the next slide, please. In terms of the recent trends, I think India does not look at AI tool as an author. We need natural persons. We have this example in front of you where a fellow Indian attorney tried to register a copyright work having a co-authorship with AI author, but it was initially accepted and a withdrawal notice was sent. Can we move to the next slide, please? And very much on this point, there's an ongoing case between ANI and OpenAI, which relates to web scraping. And certain issues have been found which will set the tone for AI jurisprudence from an IP perspective. And it's related to the storage, whether storage and training would amount to infringement, whether the prompts which are used, whether those would amount to infringement, whether used by OpenAI qualifies as fair use, and whether there is in fact jurisdiction which Indian courts can exercise when it comes to certain lawsuits related to servers located outside. Can we move to the next slide, please? In terms of the searching which we discussed, a local food shop in Indian city was able to enforce rights against an e-commerce giant just because the e-commerce giant felt that the prior citation in the search was not in a position to probably take action against the e-commerce giant. But as luck would have it, that call proved to be wrong, and the small food shop in the Indian city ended up taking action against the e-commerce giant, and there was an ex parte injunction being passed, which led to an injunction against the e-commerce giant. So don't underestimate any local companies which may seem to be smaller but could create nuisance for larger foreign companies. Can we move to the next slide, please? In terms of the copyright aspects, we discussed about term and territory. Now, here's a case where Gemalto Terminals, which was a defendant here, did not negotiate a proper contract and pushed Pine Labs, which was a plaintiff, to seek an assignment which clearly stated that the term and territory was perpetual and on global basis. And eventually Pine Labs sued Gemalto when they started using it beyond the 5-year term and beyond India, and they were able to secure an injunction on that basis. So it's important that localization, as I said, under Indian laws becomes important, and you need to mention the term and territory. Can we move to the next slide, please? The next one relates to the first filing license, as we spoke about earlier. Now, here's a case where Self-Dot tried to register, they sought a license because they were Indian resident inventors to first file outside India. But when it came to the patent of addition related to the base application, they did not seek this license. And that created a problem. And the Indian Patent Office said they rejected this application, saying that it contravened the first filing regime and the provisions which existed under that. Fortunately for Self-Dot, the Indian court was lenient, and they mentioned that it's a technical issue and that could be sorted out because in the base application, a license was sought. But again, it's important that first filing norms need to be followed under the patent regime. Can we move further for the takeaways, please? So in terms of what can we conclude as such in terms of the takeaway? I think India has a very IP robust regime, and one need not be scared that, okay, probably in India, our inventions are not safe or our marks are not safe. That's not how one should look at it. You've seen newer forms of reliefs being granted, John Doe's and dynamic injunctions, and the IP regime is to that extent very robust. Due diligence and prior search is important. Also, freedom to operate search is important. File early, record early, and enforce early, as we spoke earlier. Global IP policy and India structuring is important from a localization and global compliance perspective. Monitoring for infringement becomes important in all mediums under Indian regime, including the registrar of companies. Governing law jurisdiction in IP agreements becomes important. We spoke about reciprocating territories, issues from arbitrations, those need to be looked at. Disputes, choose forum and remedies strategically. I think you need IP benches to deal with your disputes, not courts where you don't have IP benches. Localization of IP clauses becomes important, as we spoke about. And generally, I think it's always better to seek an Indian counsel in terms of all the nuances which you have. And with that, I would like to end the presentation. And a big thank you for all the audience who joined this presentation, and I would hand it over to Tanu back.
Thanks, Shalendra. That was an excellent presentation, and I know that IP can be extremely complex, and in the Indian context, it's fragmented across different legislations, judicial proceedings, etc. So I think it was a wonderful crash course on all of it together. But while you were speaking, I think we've received a number of questions on the chat box. So I've taken a note. We may not have time to cover all of them. And whatever we don't cover to the audience here, we will get back to you with responses offline. But I've taken a few common ones across, theme and picked some of them. So let's see. Sharon, first is on the AI aspect of it, and I think globally everyone's sort of grappling with it. And you had a really interesting slide in your presentation as well on how AI output does it enjoy protection or does it not enjoy protection. So where do you see this? One is, does it at all enjoy protection in India? And if it does not at the moment, then how do you see this shaping up in future?
So I think, Tanu, good question. And being a traditionalist, I would say that something which is derived from an original work may not always enjoy the protection. But I think we need to adapt to the newer systems. And probably the move would be that probably the training data, if it is something which does not create an output which is a substantial reproduction of the original work, probably the training data is something where we could see a change in the laws in future, where that may amount to fair use if the purpose is different. But as the law stands presently, it may amount to an infringement. But I do see certain changes coming up in future on the output front.
Got it. And AI, of course, is a technology by itself, right? And certain kinds of technology and certain kinds of software, at least, are patentable. So how does that play out in the context of AI? One, is every software and treated as an invention in the context of patents? And how does that interplay with AI?
So again, computer software patentability has undergone a lot of changes over the years, and Patent Office has been sending out guidelines and which are evolving. And there's not one guideline as such. There are multiple guidelines which have been issued, and to that extent, we're quite similar to the UK regime, where we need to bring out a technical effect, or there has to be a synergistic effect between software and hardware to get a patent related to software. But it should not be a software per se. It cannot be an invention which does not have a hardware element in it, just to explain it in layman terms. And a similar thing would also exist when it comes to artificial intelligence related inventions. If you have the hardware interacting with the software, the synergistic effect may probably be protected in future.
Understood. Great. The next one is more on the dispute side. One question is, from a IP dispute standpoint, is is arbitration a better mechanism to resolve these? And should parties include an arbitration clause at all in the IP contracts?
Well, I think it will depend on which partner you're looking at in India. If it's a if it's a partner whom you trust, if it's your subsidiary where you have control over it, obviously arbitration can be considered. But if you're looking at a distributor without any shareholding from the foreign entity, then it's an outside party, so to say. And in that regard, I would suggest that arbitration in case of IP infringements with the dispute, if there's a dispute with the distributor, it's best that you don't include that as part of the arbitration regime. The reason is that you may be in a position to make use of the IP benches rather than the arbitration judges, which would otherwise hear should there be an arbitration clause. So if it's so the short answer, related company, you can use arbitrations. If it's an unrelated company, a distributor, or someone whom you probably don't trust, then you may prefer to not utilize arbitration and rather take the court route.
Understood. But sometimes, Shailen, this I'm just throwing in here. Sometimes, IP as is structured as part of a larger transaction, and typically, your larger commercial transaction would have some sort of arbitration
True.
mechanism built in, right? So now, then, how does that play out in the context of that one ancillary IP contract, which may be part of the larger bucket of documents?
I'm glad you raised this because that's a usual debate which we have with our corporate team also in many cases, because corporate lawyers don't want to change the dispute resolution clauses because that's something which has been agreed between principals. And here comes the IP team or the IP lawyers as such. They would come and say, no, we need to change this. So yes, it's better to be consistent for most of the transactional matters. But if you see a situation where the local partner is not that trustworthy, it's always best to have a differing view for IP agreements as such.
Got it. And just, staying on contracts and transactions, I think, this is another one which is my favorite actually, and we deal with it so many times. What happens when there is a contract between two parties where the governing law is a foreign law, right? Do we still, and maybe, there is some element of IP which either originates from India or is sold from India, or is going to be used in India in some ways. How do parties then first of all decide what is the best governing law in the context of IP? And if it is a foreign law, do we still need to look at that contract from a Indian law standpoint?
Yeah, I think you can retain the same foreign governing law. But it's still important to localize the contract because you don't want a situation that there are complications. Like we were dealing with one of the cases for a US company, and the governing law was US law, and the creators or the authors were Indian authors. So under the Indian law, it was considered to be an Indian copyright work. So we didn't want a situation where there could be complications in future. So we retained the governing law as US laws, but we localized in terms of the term and territory, having a specific assignment clause in it, which made it more robust and more adaptable from an Indian as well as a US point of view.
Understood. Um, the other one I think is again, switching back slightly to the dispute side. And you sort of covered it very interestingly in your presentation as well, right? Infringement has both criminal and civil remedies under the Indian framework. So somebody who is an IP owner and wants to take action, how do they sort of decide what is the best course of action, or should they strike both ways? What do we do there?
No, so they could also strike both ways because there is nothing which stops them from filing both civilian and criminal remedies. But it all depends on the eventual goal. Because if you're looking at a rank counterfeiter who's quite notorious and who's likely to repeat it, Probably criminal remedy is much better because you want to create a deterrence, because once the police authorities land up at the doorstep, it leads to a problem when it comes to the counterfeiters. But if you're looking at a more institutionalized sort of a company which is infringing on, say, similar marks and is not such a rogue company, then obviously a civil remedy is much better, because you would want injunction, you would want an institutionalized way of functioning like what a civil machinery functions, unlike a criminal machinery where there could be complications in terms of the police authorities not being aware of laws, whereas civil courts may be aware of laws. So I think you need to decide on your eventual goal to actually decide on the right forum.
Understood. Great. Another one that I have here is, I think, again, a very common one that is asked also, but would be great to cover here as well. So, supposing there's a foreign IP owner who sort of owns a trademark outside of India, but let's say has not filed for registration in India yet. To what extent, some sort of trademark protection is available in India? And, that could be, I'm just flipping this question, it could be vice versa also. Somebody has registered in India, and then to what extent do they have protection outside of India?
No, so I think outside of India, within India, certainly you need a proper registration and you need to decide on your filing strategy as such. Like we discussed, Madrid Protocol may not be the right route in each case. Probably it's also where your marks are registered abroad. Obviously, then Madrid Protocol makes sense. And national registrations to that extent may not be that useful. But in terms of global side of things, if your mark is well known for a foreign investor, I think that trans-border reputation would be protected in India and vice versa as well. So despite there being no registration in India, and if you're coming into India with that kind of reputation, the common law aspects may protect that trans-border reputation as well by the time you receive your statutory protection.
Understood. And on the Madrid system, one, if, briefly, what is the Madrid system? And are there disadvantages to utilizing that from a Indian trademark filing perspective?
So Madrid system, many people have a mistaken belief that it's an international registration which you get in at one go. That's not how it is. It is actually just a hub which the World Intellectual Property Organization has created, where you need to register your base trademark application from your base country with the World Intellectual Property Organization. And from there, you start routing your designations to various countries. And amongst them, one of them would be India. So it is not as if that you register it somewhere and you just get a one-shot registration. You have to go through each designation registration in each country. The only difference is that you don't need trademark attorneys if there are no objections. So you would only engage local trademark attorneys if there are objections being raised for each local designation. And in terms of differences which we discussed, there are certain problems like the transformation process is not recognized in India as yet. There are no divisional applications in India. Even from a first to use system point of view, Madrid applications inherently come with intent to use basis. So you need to file a separate application to claim use once you designate India. And many foreign investors or applicants miss out on that.
Understood. I guess best to just seek counsel of an expert about this. I think we have another interesting one here. IP today, I think where it's stemming from is this, that, today IP is at the center of any business, because it's so technology driven, and then there's branding and trademarks and, so it's possible that a certain IP is a combined output of multiple kinds of IPs, right? It's a composite sort of asset. But then we have different tenures of protection for different kinds of IP. Copyright is 60, trademark is 10 years, patent is something else. So, one IP owner who owns all of this, how do they sort of go about and keep track of what is expiring when, and what is the best way to sort of manage this?
So usually you have management softwares to maintain all the IPs, and then there is usually either the in-house team maintains that on the software with a proper docketing system, where reminders are being electronically sent, and for ages to come, those reminders go on coming, and even if the team changes, the reminders are sent across to a central ID. So any IP owner should have a central management or an electronic system, either through their council or through their in-house team, which can remind them about all the docketing reminders or any responses to be filed, renewals to be filed, and that's usually, and I think it's quite advanced at this stage. Gone are the years where you would see physical files being maintained. Everything is electronic, and you need that electronic sort of handling.
Understood. I think I'll take maybe two more. So, we spoke about, John Doe orders during your presentation. And I know that it's, very, very commonly being availed as a remedy of late, especially in the digital sort of context. But just practically, once you've received a John Doe order and you've received that order in your favor, how does the enforcement sort of practically pan out? Do we have to keep identifying infringing parties and then send that order to an infringing party, or does it sort of automatically remains?
No, you need to add those parties, but which is still better than filing a fresh action. So you need to go back to the court registries to identify that additional infringer which you have identified, because initially it was not identified, and that's why it was a John Doe. But then you keep on adding those parties by going to the court registrar and see extending that injunction against those parties.
Got it. And I think the last one here, and there are many other questions, but maybe we'll deal with them offline. But the last one to wrap up, you know, why is IP structuring important before someone wants to enter India? And I often say that as well to the clients that I'm advising is maybe IP needs to be the first point to start off on before you get into a JV or a merger or whatever else, or to set up shop in India. So just some pointers on that maybe.
Yeah, so eventually, money, it's all about money. So you're likely to have a wrong structure, and you're going to eke out more tax for paying certain taxation amount to the government. You don't want to do that. So structuring, I would say, when you say IP structuring, it is not merely IP. It is got to do with tax first, and there is also employee aspects as well, because you don't want a problematic structure which makes you pay more taxes, creates a problem from an enforcement point of view, which affects the valuation of the company. Again, going back to the monetary aspect, that if a faulty structure is devised, it will lead to a lot of taxes being paid, a lot of valuation issues, and a lot of enforcement issues also, which is likely to affect you globally.
Got it. Thanks, Shailendra. We do have some more questions, but like I said, to the audience who very kindly post their questions in the chat box, we have taken note, and we will get back to you with our responses offline. To wrap it up, I'd like to thank Shailendra for sharing his excellent presentation and his experience with us today. Like I said, I think it was a fantastic crash course on the overall IP framework in India. After the webinar, we will send you a copy of the presentation. We'll send some summary notes, and we'll also send a link to the recording of this webinar. So, you can catch up on it offline whenever possible. You will also receive a request for your feedback on the webinar. I would urge you to please take some time and send us your feedback, comments, criticism, compliments. Everything is welcome. The form will take less than 1 minute to complete. And lastly, thank you everyone for your attendance today. And we look forward to being with you again in future Investing in India programs. Thank you, everyone.
Thank you.